screen and screen stuff and do Facebook that way.
All right,
And
so
I've used that a ton.
oh, here we go.
Do Facebook that way. Cool.
All right, so oh, here we go.
We're streaming. We're live.
Action!
Is that on right now?
Looping.
There's there's a bit of an echo there, so I've muted the computer audio, and
All right.
you guys are live.
We're live. That's it. Hey, buddy. How's it going?
Oh, hey. Nice to see you.
You too. So I'm Ben,
I'm Eugene.
and we are going to talk about the Federal Court of Appeals.
Appeal.
Yes.
Although there were multiple appeals.
True.
We
Good
can
point.
get into that.
Right. So for anybody who doesn't know, Eugene works for West Coast Environmental Law. Wrote 2 different blogs that I think are probably the best overview of what has actually just happened with the appeal process around Kinder Morgan that I've seen. No, thank you. I've been sharing them all over the place. So I thought, given that we get a ton of questions about what is happening in court, what just happened in court, what to anticipate, I was hoping you could just give us the quick 101 of, first of all, kind of what just happened and what it means, basically.
Sure. So last Friday, the 13th of October, the Federal Court of Appeal wrapped up what was the longest hearing in its history. And that was a consolidated hearing of 15 different appeals to both the National Energy Board's recommendation and process on Kinder Morgan's Trans Mountain pipeline, as well as the cabinet's decision that was based on that NEB decision.
Right. That was the this was the Trudeau government decision.
That's right.
Okay.
And so the federal court amalgamated those legal proceedings into one hearing, and they heard them all together because there was many similar facts and so on, with the idea that it would be a bit more efficient of the court in terms of the court's time.
Right. Who are the litigants? There's a bunch of First Nations.
That's right. So there are by the start of the hearing, there were 6 First Nations litigants. Let me test my memory. Tsleil-Waututh, Squamish, Stolo, Coldwater Band, Upper Nicola, and Kamloops.
Nice, well done.
As well as the cities of Burnaby and Vancouver. The province of BC was an intervener, which many of you saw in the news.
Right.
And then on the other side, we had Kinder Morgan, Canada together, and then the province of Alberta, who had intervened as well. So of course, then the National Energy Board was part of that that respondents group.
Lovely. Okay. So, and basically, if any of those litigants win in court, this could stop or delay the Kinder Morgan pipeline.
That's exactly right. So the case has the potential to overturn the decisions that resulted in the Kinder Morgan approvals, whether at the National Energy Board level or at the cabinet level. The way that I've been describing it to folks is essentially that there's all these different legal issues and legal errors that have been advanced by the First Nations litigants as well as the cities and others. Sorry, I missed 2 environmental groups.
Oh, thank you.
Who have also part of the litigation: Living Ocean Society and Rain Coast Conservation Foundation.
Sorry, guys.
And so any one of those legal issues could result in the certificate being quashed or sent back or paused.
Right.
And so the way I've been describing it is essentially that Canada and Kinder Morgan and the National Energy Board have to bat 1,000, or to keep it in a hockey context, they have to have a 1,000 save percentage.
Right.
Whereas any one of those legal issues has the potential to in fact quash the decision.
Gotcha. And so, I mean, there's a wide range of arguments. Obviously, we're not going to go through in detail every one of them while we're sitting here, but I mean, just kind of broad strokes, like there's kind of a range. And I know you cover this in your most recent blog for anybody who wants to see it more. I'm sure it's in the comment field below where you're watching this. But if you could just kind of give us the broad strokes, like the sort of generally speaking what the arguments are.
Yeah, broad strokes, there's basically 2 categories. One is legal statutory errors, so failures to follow existing statutory requirements, including procedural fairness and so on. And the other one has to do with Aboriginal rights and title and the consultation owed to those. So as we saw in Enbridge Northern Gateway, a case called Githala, that incidentally was the previous record holder for longest case, which of course overturned the federal county decision in that case.
And almost exactly a year to the day that this
exactly
case
2 years, 2 years to the year, exactly.
Yeah.
So as we saw in there, it was the failure to meet the duty to consult by the Crown that ended up ultimately carrying the day on that case. The court said that
I thought Trudeau canceled that. That wasn't Trudeau.
It was put into Trudeau's court to see what to do with it afterwards.
Right, gotcha.
So the federal court in the Enbridge case overturned Harper's approval based on Harper's inadequate consultation.
Right.
Trudeau had the opportunity to try and remedy that, made a decision not to.
Gotcha.
And that's how it died, withered on the vine,
right,
so to speak. So in the Kinder Morgan case, we have a range of arguments around the failure to consult, to meet the duty to consult.
Right.
I think it's really important for our viewers to recognize that each individual nation enjoys that right, has that right, independent of each other.
Right.
And that the court will look at each of those nations' independent, unique circumstances, rights, and consultation record to make that determination. So, in other words, if they happen to find consultation was adequate for one nation,
in their opinion,
there is no guarantee that would be the case for all nations.
Right. Just if they could say that nation X, Y, or Z was consulted, but that doesn't mean all First Nations were consulted.
And that played out in the case too, right? So, for example, Coldwater Indian Man, they were primarily focused on the impacts of the pipeline to their drinking water source.
Right.
Right? And in particular, the failure to consider alternatives that would have, not put their drinking water at threat.
Right.
Whereas Tsleil-Waututh, for example, was largely concerned about have lots of concerns, but many of their concerns focused on the impacts of marine shipping,
right,
and the sevenfold expansion in tankers that would come as a result of the project, literally in the kitchen, not in the backyard, in the kitchen, as Charlene Alec often says,
right,
of Tsleil-Waututh.
Right.
Other nations like the Stolo bands, for example, already had established fishing rights by the Supreme Court of Canada in a case called Vanderpeet. And so the things that Stolo argued were that Canada treated established fishing rights just like any other right, any other asserted right. And if that's the case, what's the point of having established rights?
Right.
So there's a range within the Aboriginal rights and title arguments. The second category would be errors in law in terms of upholding statutes. So one that's had a lot of play and a lot of discussion is around the failure to meet the requirements under CIA, Canadian Environmental Assessment Act 2012, in reviewing marine shipping by the National Energy Board. So the National Energy Board did a bit of legal sleight of hand by reviewing marine shipping only under the National Energy Board Act, but not under the Canadian Environmental Assessment Act, which allowed for them to find that the tanker traffic would have a significant adverse effect on the southern resident killer whales, but they didn't have to do anything about it.
Right.
Under CIA, they would have had to come up with some sort of mitigation plan. And likely would have invoked the Species at Risk Act, SARA, which of course would have provided more protection for the species at risk, and that was a big part of the living oceans and marine coast conservation argument.
Right. Gotcha. Okay. So, and is that basically the broad strokes? Like there's the two different pieces that you're talking about around First Nations rights, and then around what they should have considered, whether they did or not. What do you? I mean, I don't want you to rank these various things on what you think the strongest arguments are, but I'm kind of curious what you think will be some of the more difficult questions for the court to consider.
I think there's a couple of themes that we saw pop up. One of them is, what does consultation look like in an era of reconciliation where the courts have already clearly said that Section 35 and consultation rights are grounded and tested by looking at the honor of the Crown. Is the Crown acting honorably? And secondly, are grounded in the spirit of reconciliation, right? And so my question is, and this is partially a legal question, but it's more actually a broader question that I think we need to be asking ourselves of our leaders, of our representatives in the form of the Crown government, is in the age of reconciliation, do we want the Crown governments, the provincial and federal governments, to be aiming for the floor, for the bare legal minimum when it comes to consultation?
Right.
Or should they be aiming higher? Should
Right.
they be trying to exceed
Right.
those bare legal minimums?
I mean, if you take what our Prime Minister said at the United Nations recently at face value, you would assume that we were not shooting for the absolute bare minimum.
I would hope so, and I think that's partially what the courts have been slowly doing, is unearthing what the bare legal minimum is in certain circumstances. Of course, it varies from case to case, and so that's a question that that they're wrestling with. Another one of the themes is essentially, you know, what Canada was saying, and which I've talked about in the blog, is essentially court, you have to yield to the cabinet decision, which was necessarily a polycentric decision, which balanced many different factors, and then they made this tough decision.
Right.
And that the courts should be deferential; they should yield to those
Right.
decisions. That's not the court's role. And what the First Nations and the other applicants are saying is essentially, you can't give deference to a polycentric decision if it was arrived at in an unconstitutional way,
Gotcha.
or if it was arrived at while breaching other statutory duties.
This is basically the balance between what is politics and what is the role of the courts.
Exactly right. And so that's a big philosophical question that the courts are going to have to answer, right? Generally speaking, and I think it's probably the right thing, courts tend to not weigh in on big complex policy decisions because that's not their expertise. There's trade-offs. Courts are not accountable to the public in the same way that politicians are.
Right.
But at the same time, in a constitutional democracy, the only thing constraining government action is the court's application of the Constitution and the court's requirement that those decisions are also consistent with the legal requirements.
Right.
That's where the balance is, and that's going to be really interesting.
Where do you go when your rights aren't respected by the elected government?
And can a polycentric decision stand if it violates other sections of the Constitution?
Right. Interesting. So this sounds like it's got big implications beyond just this one project.
I think absolutely, and that's why it's been getting so much interest and attention across the country and indeed across the world. I've been getting calls from people in other countries, both environmentalists, but also financial analysts looking to understand, also Indigenous rights supporters, because it does raise so many issues that are bigger than just one pipeline. It's, you know, climate change is implicated through the connection with the Alberta tar sands and the ability to move these types of projects forward. Obviously, Indigenous solidarity, Indigenous rights, and the right to free and prior informed consent also embedded within the arguments. You know, as we've seen play out both in the media and in many ways in the case, the very nature of Canadian federalism and what the federal government can do when a province like BC is opposed to a project that for which it will disproportionately bear their rights.
Does the federal government push something through without the province's consent, without First Nations consent?
Exactly, and that extends, I would argue, as well to the whole question of cities and what is their role. You know, cities are not protected or not created by the Constitution. They're a creature of statute from the provinces. Yet, as we know, municipal governments are the ones who are both dealing in a very real way with the current impacts of climate change, as well as dealing, you know, with the challenges of jurisdiction and all these other pieces. And so I think that's also an interesting piece of the question. And then finally, as I mentioned, just the very nature of our constitutional democracy, where we have in the current legislative scheme a federal cabinet that makes a decision in a black box behind closed doors.
We still don't even know the positions of the various members of that caucus.
Exactly, and they do this. They are able to use cabinet privilege to shield any of those deliberations from public scrutiny. And then they issue very sparse reasons that wouldn't meet the normal standard of an administrative tribunal, let alone a court, in terms of making it clear within the reasons why the decision is made, rather than just the conclusions that have been reached, which is kind of more what we saw.
Right.
So I actually think it also undermines a very key and fundamental part of a constitutional democracy, and that was essentially embedded within the BC Attorney General's arguments before the court last week.
Gotcha. There's so many pieces of this that I would love to dig into deeper, but I know that you've got an event you've got to get to pretty soon. So maybe I'll just end off with this. You know, what do you think the timeline we should expect some sort of a decision?
Yeah.
And could you give us a sense of like kind of the best case or like the range of outcomes that we could anticipate?
Sure. So, you know, in the Enbridge case, which we'd already mentioned, kind of happened almost 2 years to the date. The court took 8 months. It took until June to issue their decision.
Right.
In the current case, we've had clear statements from the court that they believe getting a resolution to this issue is in the public interest. I'll note that the court also said similar things in Enbridge.
Right.
And for a case this complex, you know, 8 months, although it seems like a long time, is actually not that long of a time.
Right.
So my best guess is, you know, somewhere between 4 and 8 months we might see a decision.
Right.
The range of outcomes could go all the way from rejecting all of the legal arguments.
This is the batting 1,000.
This is the batting 1,000,
Yeah.
say 1,000 save percentage,
Right.
you know, shutouts across the board scenario.
That seems hard to imagine.
Which would uphold, well, we'll see. I mean, who knows in terms of range of possibilities. To you know, identifying legal errors, whether at the NEB level or at the cabinet level, and often it would be referring back to those bodies to try and correct those errors.
Right.
And then whatever, depending on what those errors are, would kind of inform what the remedy is.
Right.
I think it's important to remember, though, that no matter which way the courts decides on this, it's potentially and likely going to be appealable to the Supreme Court of Canada.
Right.
There's no guarantee, of course, that the Supreme Court of Canada will give permission or leave to appeal it.
Right.
But I think because of the range of issues involved, because of all these things that we've identified, it's you know, it's certainly possible and plausible, if not likely, that I would say it's guaranteed that whatever way it goes, the losing party will be having a good, long, hard look at the potential for an appeal to the Supreme Court of Canada, which of course could add years.
And in the meantime, Kinder Morgan is trying to give the impression that it's all moving ahead with this project.
Well, it's interesting because one of the things that Kinder Morgan said to the court in the hearing was that they would not put shovels in the ground until they had all their permits.
Does that include shovels in the water? Maybe that was the...
I think that's part of, you know, we will see what happens. But certainly it's clear they don't have all their permits. It's also clear that in some cases, like with the salmon mats, they've decided to begin work without permits.
Right.
And so I think really what we have to think about is, you know, how much do we or should we trust the regulators to enforce their own conditions, or how much, in other words, how much do does the existence of these conditions actually address the issues?
And that's a range of regulators too, right? Like we're talking provincial and federal jurisdiction.
Yeah, and I mean and that's also part of the whole premise of some of these lawsuits.
Cool. All right. Well, that was super interesting. Thank you so much.
Thanks for having me.
If you're out there watching this and there's anything that you've got questions about that we talked about, or there's something more that you want to know, I mean, I guess the first thing I'd say is read those 2 blogs.
Read the blog.
Which you can find in the comments, or you can find
here.
it, yeah, right here. Right here, or here, depending on how it could be over there. Probably here. But, you know, because this is on YouTube, Periscope, and on Facebook at the same time. We're testing out this new thing. Thanks for helping.
That's really what we're doing here. We're just testing.
Yeah, we're just having a conversation. But yeah, if you do have any questions, please, you know, feel free to post them right in the comments or send us a message on various platforms. Click a button somewhere. But we can always continue this conversation. You know, I think there's going to be a lot more to talk about in the months ahead, and I very much appreciate your time to help clear some things up.
Thanks for having me.
Okay.
Take care.